This is Larry the Law Tutor with 7 Sage Law School Prep and another stick figure exam tip. This one's called Imposing Structure on a Contracts Exam. Contracts is a little bit tougher in my mind than crim and torts. It's not as transactional. There are a lot of interlocking pieces that you have to deal with on a contracts exam that you don't with torts or crim. With torts or crim, you have a lot of discrete things that happen. Somebody gets shot in the face or somebody gets shot in the butt. And each one of those constitutes a different crime or tort. Generally speaking, this is not how a contracts exam will take place. Generally, you'll have one or two or three, but not very many contracts at issue in any given contracts exam, and you'll have to analyze those in great depth. And that can be kind of scary. It's easier to go through picking up murders and intentional inflictions of emotional distress and that sort of thing. And it's a lot harder to go through one or two transactions in which many things are said and done and come up with basically at the end of the day a single number assessing damages. This is even harder when the law that you're given is presented as this crazy word collage. You've got condition precedent in Article 2 of the Uniform Commercial Code, and expectation damages, and consideration, and unilateral mistake, and promissory estoppel, and liquidated damage, and all of this shit to deal with. Hopefully you can notice the ones that don't apply here. And very little structure imposed on this, and even worse, no real way to approach a contracts problem. And I've seen contracts taught this way by very good contracts professors. And on the bar exam, it's presented similarly confusingly. So here's my quick guide to imposing order on a contracts exam. There are just 3 pieces you have to deal with. So pretend that this is a normal contracts exam. Normally, I'll come to an exception in a second. Normally, there are just 3 pieces. You identify, and let's pretend this is text, 1, the obligation, if there is one, the breach, if there is one, and damages, if there are any. Each of these is a very complicated thing with many, many subparts. Whether there's an obligation can involve whether or not there's a bilateral contract, and that in turn is based on acceptance, offer, consideration, unilateral contract, and so on. Each of these is full of the immensely rich body of law that you learn for contracts. But this is the tip. Almost every contract fact pattern can be broken down into 1, 2, or 3. Obligation, yes or no. Breach, yes or no. Damages, yes or no. Now, the one exception to this is in some instances, maybe you get a partial question and the professor is really just asking, is there an obligation here or is there a breach here? But you'll usually find that in the call of the question, which is usually at the end of the exam. If you're simply told, assess the claims of the parties, I would look to break the exam down into these 3 pieces. If you're given a more specific questions like, does Abel have an obligation to Cain, you may know just to analyze one of these sub-bodies of law.